on these subthemes. Application of basic structure doctrine to the powers of promulgating ordinances. In this presentation, I will be dealing only three things. Why to apply this doctrine on promulgating ordinances, powers of promulgating ordinances? What is the advantage if we apply this doctrine? And thirdly, how will you apply the doctrine? What should be the set of arguments that needs to be formulated to apply this doctrine? So only three things: necessity, advantage and mechanism. But before that, allow me to brief you something about the power of promulgating ordinances. Article 123 grants power to President to promulgate ordinances, and Article 213 grants power to Governor to promulgate ordinances, and these two articles are having similar provisions. Article 123 is conditional in nature. This means there are three conditions that needs to be fulfilled as per Article 123 clause 1. First, at least one of the houses is not in session. Secondly, President is satisfied that there is some legislative emergency, and thirdly, there is a need for an immediate action to cure that emergency. Now, Article 123 clause 2 states that ordinances to have the same force and effect as an act, and it gives a duration of its life, that it shall cease to operate at the expiration of 6 weeks from the reassembly of Parliament. But if it is read with Article 85, that the President has the power to summon another house after 6 months gap, so the maximum life duration can be tentatively 6 months and this 6 weeks from reassembly. And Article 123 clause C tells about the competence of promulgating ordinances. It is equivalent to the competence of Parliament. Now, what is the intention of Dr. B.R. Ambedkar while framing this promulgating power? What he thought? He faced a lot of objections from other members of Constitutional Assembly, and they said that you should not make such provision due to separation of power. Separation of power doctrine states that it is the legislature who should legislate the laws, executive to implement them. Why are you giving this power to the executive? There he states of a hypothetical sudden and immediate situation which could neither be dealt by existing code of law nor the ordinary process of law can be resorted to. Just look at this intention of Dr. B.R. Ambedkar. He says when there is no such law in place to deal with that emergency, and secondly, you do not have time to move to the ordinary process of making a law. That means, look at the second point, that means there is a hope of Dr. B.R. Ambedkar that owing to exigencies of parliamentary business, there will be more frequent sessions of parliament as government will have to maintain the people's confidence. That means when there will be an emergency, first an effort will be made, let's make a law, let's legislate upon it, and if it's not possible, then move to the route of ordinance. But does that hope last now? How is that hope being fulfilled? Are efforts being made to first legislate and then move to the ordinance route, or efforts are being made to surpass the process of legislation and move to the ordinance route? This comes the necessity. As per this data I have somehow got it, ordinances by central government, see the range from 1950 to 2023 till 22nd May 2023. If we may give an average to it, almost 10 ordinances are being promulgated each year. But an astonishing number of emergencies happening in India that cannot be cured by any existing law, or the ordinary process of law can be resorted to. But Dr. Ambedkar, what he said that when there will be such emergency, ordinary process of law will be resorted to, and more frequent sessions of parliament. Let me just tell you, look at the third bold line, more frequent sessions of parliament will be held. But looking at the sittings in lower house, it declined from 121 to 68 days. This is very contrasting. There are two questions. Are there actually such emergencies? And if there are such emergencies, then why low sittings? And if we look from the other side, if there are low sittings, does that mean there are no such emergencies? And if yes, if there are no such emergency, then why the route of ordinances? Why so much ordinances are being promulgated? Does this attribute ill motive to the executive? Is the executive trying to do something, do some kind of fraud on the constitution? There comes the necessity. There are two examples of ordinances and the criticisms I have mentioned. The Criminal Law Amendment Ordinance in 2018, it was promulgated, which said that there will be imposition of death penalty for rape of children below 12 years. One of the significant criticism to this ordinance is that it's a populist move to quell the protesters of Katwa and now rape cases. Now, this thing was done as per the criticisms, not due to some emergency, but to quell all these protesters and it did not have any retrospective effect. That means those who have been committed these crimes, they can get free. They are not under the clutches of these ordinances. Then what are these ordinances remedying? A similar example is the Fugitive Economic Offenders Ordinance. Now moving forward. This attempts show that there is a clear intent that they want to avoid the deliberations and scrutiny of legislature. As per Dr. Shubhankar Dam, he mentioned in his book some reasons why these ordinances are being frequently promulgated. There is one kind of reason called attitudinal reason, which is divided into two parts. First, Parliament as a cumbersome institution, and second, the executive sees Parliament, they have a contempt for Parliament. That is, they want to surpass the Parliament due to somehow, if they lack majority in the House, they think that the law cannot pass. So simply let's surpass it and move to the ordinance. It is this necessity that I say the ordinance route is being misused and a substantive judicial review needs to be done. Why a substantive judicial review? Because the prevailing judicial review, which I say is formalistic in nature. As Article 123 Clause 2 says, that ordinance will have the same force and effect as an act of Parliament. From there, only two limitations can be derived that are applied to an act. One is lack of competence, another is infringement of constitutional provisions. However, in 2017, in Krishna Kumar case, Justice Chandrachud, taking inspiration from the S.R. Bommai case, where a test was let down to test the President's satisfaction under Article 376, the emergency provision, and that test was taken from there and applied in ordinance. That test is the first time. Court can interfere in presidential satisfaction under Article 123, where exercise of power is based on extraneous grounds and amounts to no satisfaction at all. What does that mean? That means the problems is that correctness, adequacy and relevancy of materials cannot be relied upon for such satisfaction. So, how a president makes a satisfaction? There will be some kind of materials given to the president or the cabinet, they will be perusing it, and then the president is given this formally, the president is satisfied. So even if those materials are vaguely relevant, they are not relevant to the emergency, we cannot assess the correctness, the adequacy or the relevance of those materials. That is why I say it's formalistic, it's very limited and weak. And second thing is, in S.R. Bommai, this test was applied to presidential satisfaction, but that was under executive power. The president is exercising executive power under 356. But in 123, president is exercising legislative power. As per the chapter name, legislative powers of president. So how can a test which is applied on executive power, how can that be implanted on president's satisfaction legislative power? And to do that, what needs to be shown? For that cross application, it needs to be proved that ordinance making power is not purely legislative. It has some hues of executive power as well. That means it's a mixed nature of legislative power and executive power. And how is that inferred? That I will be presenting further. Now, after understanding the why part, I have described that there is necessity of it and there is a formalist judicial review. So we need a substantive judicial review. And I propose that applying the basic structure review, applying the basic structure doctrine will be a substantive review. What is the advantage of it if we apply it? Kindly note this example. An ordinance is promulgated 2 days after a session ends, or that's a typographical error, or before a session starts. For example, one of the houses ends yesterday, and next day an ordinance is promulgated. So was the executive waiting for the session to end and then to promulgate an ordinance? Or in that 24-hour span, the executive got an idea, oh, there is an emergency, let's promulgate an ordinance. I think the second part is I do not feel it is correct. The emergency must be lasting. That means the executive was waiting that the session will end and then I will take the ordinance route. But can that action, can that be challenged under the prevailing judicial review? Lack of competence. There is no lack of competence. Infringing provisions of the Constitution. Let's say the content of ordinance is very fine. It is not infringing the provision of the Constitution. Based on extraneous grounds. No, the material is also relevant. Everything is correct. But is it right? I do not think it is right because they wanted to surpass the legislative process. But can we challenge it with the existing judicial review? To my mind it comes no. We cannot challenge it. But how can we challenge it? If a new ground of review to be added to test the effect of such ill exercise of promulgating power. What is the effect of that action? The effect of that action that I am promulgating an ordinance after waiting the session to end clearly affects the doctrine of separation of power and parliamentary democracy, which are the basic features of our constitution. What does that say? Separation of power says about check and balance mechanism and that the legislature will legislate. And secondly, parliamentary democracy, there has to be proper deliberation, debates, discussion before a law is passed. But these things are being hampered, that too, with an intention. So here I say that if we test the effect of such action through some mechanism, the effect test, then this thing can be challenged. Now how this effect test can be implanted in our Indian constitution by our Indian judiciary? So here I suggest that the ordinance making power, the effect test needs to be applied to the ordinance so that the wrong that is being committed, that can be cured. And the advantage is clearly there. This clearly departs from the formalist review and model of testing motives. So what I suggest that we are not testing the intention or the motive. We are simply testing what is the effect of this action. And this thing has been done. There is the holding in UK Supreme Court held in Miller 2 or Cherry case. It has a similar kind of fact. In that case, what happened? It was a time of Brexit. The Prime Minister wanted to exit the European Union without any agreement. But the other ministers, they said no, there should be an agreement and then we should exit. But what the Prime Minister did, he prorogued the House. A long prorogation was given. Okay, and within that prorogation, the Brexit occurred. There the court held, I am reading from here, the third point, held such a decision of prorogation will be unlawful if the prorogation has the effect of frustrating or preventing without reasonable justification the ability of Parliament to carry out its constitutional functions as a legislature and as the body responsible for supervision of the executive. The court did not went into the intentional motive of Prime Minister. The court said that it has the effect of preventing the Parliament from doing its duty. Who are you to prevent the Parliament from doing its duty? It is the Parliament who will be responsible. It is a body who has a responsibility for supervision of the executive. So this is the effect test that has been introduced by the UK Supreme Court. How will you implement it in Indian judiciary? I propose that if we simply take that effect test from another jurisdiction and implement in our jurisdiction, that will not be fine. There has to be some basis for it. Something needs to be the base from which this effect test needs to be interpreted. And that base can be the basic structure doctrine. The second point, basic structure doctrine serves as a basis for adopting effect test, or it can be an equivalent term. This is the reason I said this is the advantage of basic structure doctrine, which can be used to test the effect of ordinance. Now after explaining you why and what, this comes the main part. How will you do it? It was well sounding now, okay, we have resolved the issue, but what should be the procedure that needs to be followed? Here, first I suggest that the nature of ordinance needs to be deciphered. Earlier I had stated that the ordinance needs to have a use of executive power so that the extraneous ground that Justice Chandrachud brought from an executive power and brought it to legislative power, that thing needs to have some reason. So I fill this gap by saying that the ordinance is not a completely legislative power but it's a circumstantially conditional legislative power due to the difference between ordinance and act. Some differences are there, like the competence is restrictive. It is not applied to Article 249, 50 and 52, which grants Parliament power to legislate matters in state list. So those things cannot be done with an ordinance, so the competence is restricted and there are some differences. But the main part comes here. How will you interpret the constitution in a manner so that basic structure doctrine can be applied to power of promulgating ordinance? The phrase appearing in Article 245 and 73, subject to the provisions of the constitution. Now what does this term provision means? Does this provision means the express text of the constitution, or does it include the interpretation of those provisions as well? Here I presume, or I profess put my view that basic structure doctrine is not a hovering principle. It has its roots from the Constitution. It is a result of interpretation of different articles that this basic structure doctrine has evolved. So this provision is equal to the express provisions plus the interpretation of those provisions. The definition of provision includes those provisions as well as the interpretation of those provisions. And interpretation of those provisions includes the basic structure doctrine, the implied limitations. In this way, I make a correlation and that state that the powers exercised under 245, the legislative power, and 73, that is the executive power, they are subject to the basic structure doctrine by interpreting the term provisions. And as I had stated, that ordinance is a mix of both. So even if we consider it as an exercise of legislative power, this thing will apply to it to inference that the basic structure doctrine can be applied to it because it is also subject to provisions. Even if it is considered as an executive power, still then the same route can be taken. Now secondly, I wrote about it that deciphering the type of basic structure review. Now basic structure review has evolved as an independent substantive review, as my friend has stated here, that it is applied to ordinary legislations as well, it is applied to executive actions as well. And a reason for that is presented by Chief Justice Beg in state of Karnataka, where he stated that, but if as a result of the doctrine, certain imperatives are inherently or logically and necessary flow from the Constitution's basic structure, just as though they are its express mandates, they can be and have to be used to test the validity of ordinary laws, just as other parts of the Constitution are used. That means, he states, if something naturally flows from the interpretation of the Constitution, that is the basic structure doctrine, it needs to be treated as an express mandate. And as other provisions are used to test the ordinary legislation, the same process can be applied to test. So looking at the growing scope of basic structure doctrine and its growing scope of application to ordinary legislations, executive actions, similar type of steps can be taken through this independent substantive review to put restraints on the ordinance promulgating powers. And thirdly, I suggest, and is an important question, we say that basic structure doctrine it evolved. There is a famous quote, I don't remember it properly, but it was stated, amend the Constitution as you may, but you cannot damage or destroy it. In constitutional amendments, the text of the Constitution is changed. So you clearly visualize that there is some damage or destroy, the Constitution damage or destroy. But in these actions, the ordinance, the text of the Constitution is not touched even. So how can you say that the Constitution is damaged or destroyed? The question is, how can an executive action that do not make any textual change in the Constitution damage or destroy it? An ordinary legislation doesn't even touch upon the Constitution, they express mandates. How can it damage or destroy the Constitution? So here an answer was provided by Dr. Sudhir Krishna Swamy, and I like that answer, where it was formulated that basic structure doctrine is a qualitative review. It is qualitative in nature, which is the third point. It's qualitative in nature, not quantitative. It is concerned with preserving the normative identity of the Constitution. So what I believe, do not look at the textual effacement that is done on the Constitution. Look at how its identity, how its principles are being targeted and that being damaged in this way. With that thought process in mind, this thing can be done. So it is not concerned with, this review is not concerned with the degree of textual effacement of the constitutional provisions, but preserve its normative identity. And with this, I suggest that after explaining the why, what and how, I have put my views very clear. And I propose that this application should be made, but with some restraints, which I haven't built upon. Now this is the thing that I leave for others and as well as for me to ponder.